These are appeals in the matter of Queeld Ventures and others and Vesnin.
Yes.
My lords, my lady, these two appeals are listed together. In Appeal 2024-002-667, the Tomlin order appeal, I appear with my friend Mr. Nichols for the appellant, Mr. Vesnin, and my learned friends Mr. Edwards, King's Counsel, and Mr. Pavlovich appear for the respondents, Queeld Ventures Limited and MySpare Limited. There's a third respondent, Eurasia Mining PLC, who appears by my learned friend Mr. Harrison. They adopt a neutral position on this appeal. The fourth respondent does not appear.
Yeah. In
the other appeal, 2025-000-223, the recognition appeal, it's brought by, now I call them Q&M, Queeld Ventures and MySpare, to which Mr. Vesnin, our client, is the respondent. And in that appeal, my friend Mr. Bayfield, King's Counsel, with Mr. Edwards, King's Counsel, appears for the appellants, Queeld and MySpare, Q&M, and Mr. Nichols and myself, and I appear for Mr. Vesnin as respondent. There is a draft, but agreed, a timetable for the hearing,
yep.
Which we certainly propose to adhere to, and if we can improve upon it, we will. In the sense
okay, thank you very much for that.
And shave it. You will have seen that the core and the supplementary bundles have been combined, and that there are two additional bundles, the fresh evidence bundle, if I can call it that, and the respondent's notice bundle. And I hope that they've all been lodged. Could I launch, therefore, into the what I call the Tomlin order appeal, if I may? That appeal concerns the construction of the Tomlin order dated the 14th of November 2023. That's in the core bundle behind tab 10 at page 163. The parties are broadly in agreement on the approach to construction, which is that the conventional rules apply. The court has jurisdiction to interpret a settlement agreement in a Tomlin order, and the general principles, perhaps as encapsulated in Network Rail, which are well known to this court, have full application. Of course, in the context of a Tomlin order, regard must be had to the underlying dispute that the Tomlin order was seeking to resolve. And it's right to say that in this case, it is our case that I'm not sure if I'm pronouncing it correctly, but the Denaxi and Cooper principle, which I know my lady and Lord Justice Snowden were part of the panel in that case, played a significant role in the purpose or reasons for the Tomlin order and the form that it took. And if I can just sort of remind you, because I know you've had full skeleton arguments about the background in the dispute between Q&M and Eurasia, the issue which gave rise to the litigation between Eurasia and Q&M arose because Q&M had lost their share certificates. And you will have seen that before agreeing to issue replacement certificates, Eurasia needed a protection from third-party claims, for which purpose they insisted, in accordance with market practice, upon a counter-indemnity issued by an insurance company or a recognised banking institution. And that Q&M, over a prolonged period of time, failed to provide such a counter-indemnity, and that resulted in the proceedings. They were brought by Q&M as claimants against Eurasia, effectively seeking an order for delivery up of replacement certificates. Just before trial, a compromise was reached, whereby Eurasia obtained protection by arrangements set out in the Tomlin order. They were designed to give Eurasia a different type of protection, a procedural immunity, by analogy with the guidelines given in Denaxi and Cooper.
Well, why Denax and Cooper, I'll call it, is a special category of cases where trustees or people in analogous positions, insolvency office holders can come to the court and seek approval for momentous transactions or have resolved questions of law. Who's the trustee or analogous person in this case?
The Eurasia, because Eurasia was saying, well,
Why? It's not a trustee and it's not anybody in an analogous position. It's, if anything, it's just like an interpleader, isn't it?
It took the position that for the purposes of the Tomlin order, if it was going to be protected, it needed some form of immunity from suit.
Well, it might have wanted it, but it's not normally the situation that somebody who holds property over which there are rival claims is entitled to do anything other than just interplead, drop out of the picture. But on what basis does it have an entitlement to some sort of indemnity?
Well, it's more, my lord, a question of what they agreed to and the purpose of that agreement. Why did they agree to advertise? Why did they agree to bring before the court, within the corral, as it were, third-party objectors? And the answer is, and Eurasia has always said, so they wanted to make sure that everybody had a voice and had their objections heard, so that they, Eurasia, could not subsequently be sued by those objectors.
So did they cite Denax and Cooper to the judge making the Tomlin order?
Well, we've not had any sight at all of anything that leads up to the Tomlin order. In as far as the trustee is concerned, we have no material at all.
So
what we do have...
On what basis do you say that Denax played an important role in the...
Eurasia's skeleton argument before Mr. Justice Adam Johnson, explaining the genesis of the Tomlin order. That was their case and has always been their case.
Okay.
So far as they were concerned, that they wanted
I'll say right at the start, I mean, as at least one of the panel, I'm surprised to think that what was said in Denax has a role to play in a situation like this. I mean, I will need some considerable assistance on that.
Well, can I just sort of test that a little bit on the facts of this case? You will have seen that Mr. Justice Adam Johnson, back in March of last year, gave judgment as recorded in the Otis Simmons and Simmons. And he did so on the premise that the primary purpose of the Tomlin order was to protect Eurasia, because they were giving up the fight for counter-indemnity, in return for which they wanted immunity. Then
that's an entirely commercial. It's an entirely commercial situation.
I accept that.
I mean, you know, the position with Denax and Cooper is, and we'll then put this to bed, but the position with Denax and Cooper is that the law has always been more favourably inclined to trustees, and especially, I think, made the point trustees who aren't commercial trustees, but who could be family members in various situations.
Yes.
But as you said, I mean, Eurasia was simply seeking, as a commercial matter, to get something which it had no statutory entitlement to.
I agree. I accept that.
And you say market practice, well, you know, in a sense, maybe, but basically you get, if you don't ask, you don't get. But it has no, on the face of it, the company has no right to an indemnity. It is supposed to issue certificates to the person on the register. And its concern was just, if it did, it might unwittingly get caught up in some dispute about beneficial ownership.
To be fair, going back into the weeds, as it were, Eurasia's articles, I think it's 9.6, did stipulate that when exercising its discretion whether to issue replacement certificates, it had to have regard to whether there were any indemnities or other evidence. So it had a structured discretion to decide whether or not to replace the certificates which were said to be lost within its own articles. And that in a sense, was the dispute at a trial.
Okay.
And it called evidence that it was market practice, that a counter-indemnity was required. And it served witness statements to that effect. And that was the battleground between, on the one hand, Eurasia and Q&M on the other.
With no right to an indemnity as such. You say it's an exercise of the director's discretion
Yes.
as to whether to issue.
And the question, Eurasia said that having regard to a whole series of circumstances, it was entirely reasonable for them to seek a counter indemnity because the indemnity from Q&M was worthless.
But, okay, so that the framework within which that dispute is going to be resolved stems from the Articles of Association, the director's discretion, market practice. In other words, it's a completely separate framework from the normal DENAC situation where you have people who just are trustees.
No doubt about that, my lord. I wasn't suggesting otherwise. I mean, I mean, we weren't around, as it were, at that stage. But what appears to have happened is that Eurasia reached the deal that instead of their counter indemnity, they would achieve a protection against risk of claims from third parties for wrongful release of certificates by a form, and only by analogy, of immunity from suit. And their idea was, and you're right, it's commercial, their idea was you bring everyone into the corral, they all have their voice and an opportunity to be heard. And once that has happened, as a matter of abuse of process, Henderson abuse of process, they would not be able subsequently to sue Eurasia in respect of the same matters. That was what you're absolutely, very great respect, I completely agree. It was a commercial, there was no suggestion they were trustees in any formal sense, they weren't.
And the claims that they were, well, we'll get on to the claims that they were seeking, you'd say, protection from were that they would be held to have what, knowingly interfered with or facilitated some misappropriation of assets, breach of fiduciary duty, some sort of claim of that nature.
Yes, and these were poo-pooed by Q&M. They were very dismissive, but my learned friend Mr. Harrison, in his trial skeleton argument, which we didn't see in the court below, set out at very great length the risks, how they arose, and why they were risks that they had to take seriously. And there were two principal, particular specific risks. The first was a company called Merendo, which was a Cypriot company, which was in liquidation. And they referred to that as the Merendo transaction, under which the shares appeared to have been sold. There was a full, and in fact, an inflated purchase price had changed hands, and share transfer forms had been completed. And they were very concerned that the liquidator of Merendo would complain if the shares were now released to Q&M. And then secondly, there was our client, Mr. Vesnin, because everybody was aware.
Sorry, I mean, it may be that this is, I haven't picked up this detail about the Merendo transaction, but is it somewhere in the bundle?
Yes, so if I could ask you then to turn up.
Take a reference or something if it's not.
Yes, so it's in the, shall I call it the appellants bundle? It's the CPR 52.212B bundle, the fresh evidence bundle. And it's at page 40. The skeleton argument of my lady friend Mr. Harrison at trial starts at page 34. And the skeleton argument, I think it's fair to say, focuses on identifying the risk in respect of which they wanted the counter indemnity. And if you go on page 35 of the bundle to the end of paragraph 2, in a high-level summary, he says there are 10 matters in particular that indicate the risk. And the first was the Merendo transaction. And Merendo was a liquidation in Cyprus. And he goes into this in considerable detail from paragraph 42 onwards on page 47. And the worry was that this was a colourable transaction, the sale and purchase agreement, because for the reasons that were set out in some detail by my learned friend Mr. Harrison from page 47 onwards, paragraph 42 onwards, this appears to have been, or certainly it was arguable, that the transaction itself was a way in which Mr. Ananiev siphoned money out of the bank because it was a sale at an overvalue, inflated value. And perhaps no need to go any further than paragraph 48. Mr. Harrison said the sale was therefore from one Ananiev hand, the claimant, to another Ananiev hand, Morendo, with the price inflated.
And this is the skeleton argument for the trial that then didn't happen because there was then the Tomlin order.
My lord, it is.
Yeah.
It is. And I don't, you'll be pleased to hear, wish to weary you on the details of it. There's a great deal of detail which is set out in the following pages of the learned friend's skeleton argument. I should emphasise we did not see this skeleton argument in the court below. The second specific and particular risk was the knowledge that Mr. Ananiev, and indeed Mrs. Ananieva, were bankrupt, principally Mr. Ananiev, and it was known that Mr. Vesnin had been appointed, and it was known that in Russia there had been proceedings in which Queeld had participated, establishing that Mr. Vesnin in effect had the de facto ownership and control of Queeld.
Sorry, are you going to point us to where that's covered?
My lady, yes, it's so 47 of the bundle, paragraph 41. That's where he first refers to it. It's the 5th bullet, I think. But he deals with it in more detail later on. It's page 64, paragraphs 128 to 131.
Page 64.
64, I hope, paragraphs 128 to 131. And there he identifies the fact that the Russian court had ruled after a trial that the shares in Queeld were part of the bankrupt estate.
What's that got to do with the issue of shares in Eurasia?
Well, the concern was that, as Mr. Justice Adam Johnson identified in his ruling, that the reality here is that Queeld and Maisper are mere nominees. And
So, can we just pause there, because there may be certain loose language. What I read this skeleton as having said, and I think it's supported elsewhere, is that the Russian ruling is that the shares in Queeld
yes,
are part of the insolvency estate. When you say that Queeld is a mere nominee, that's not what this says. This is saying the shares in Queeld are part of the insolvency estate. If Queeld were a mere nominee, that wouldn't really assist at all. The shares in Queeld would then be worthless.
yes.
So, as I say, the Russian court is holding the shares in Queeld part of the insolvency estate. Apparently, I would say it's rather implicit in that the court may have been proceeding on the basis that Queeld itself owned the Eurasia shares.
Yes, I don't think that's what the Russian court was necessarily proceeding along those lines.
Why does the Russian court care at all who owns the shares in Queeld if Queeld is simply a nominee? I mean, why? I mean, there's no holding from the Russian court that the shares in Eurasia are owned by bankruptcy estate.
My lord, no. It is the other way around in a way. What is said is that, and this was the basis upon which Mr. Justice Adam Johnson gave his judgment, that the issue in this court is who is the ultimate beneficial owner of Queeld, because the ultimate beneficial owner of Queeld is the person to whom, in effect, the shares will be released. if the certificates are released to Queeld, because there is no suggestion that Queeld has any function in life, no assets.
Who are the directors of Queeld?
I'm sorry?
Who are the directors of Queeld?
They are, from memory, I think, some Cypriot individuals, I think.
And so,
Well, my client has no visibility on any of that because he hasn't yet had disclosure, none at all. So he has a BVI company and a Cypriot company, but he has no documents.
your client has, on the face of it, a ruling that the shares in Queeld are part of the estate over which your client is appointed.
Yes.
What have you done to give effect to that ruling
Well,
in the relevant jurisdiction?
well, what happened as a matter of timing is that in the 31st of October is when that ruling was published, and
2023.
2023, and it was at the end of 2023 that Mr. Vesnin discovered these proceedings, and he was invited, obviously, to, if he was challenging the release of the certificates in effect to the current UBOs of the claimants, he was to come to this court.
But, I mean, if you've got a ruling that says you own Q,
Yes.
the shares in Q, and there's a suggestion that the shares in Eurasia are going to be released to Q,
Yes.
surely you just assert your claim to Q, remove the directors and take control of Q, and then the shares will be delivered to you.
The trouble is he can't do that in Cyprus in the time that he's got.
What, since October 2023?
That's right. So he has, in the first instance, he is saying to this court in response to
So you say that, but why?
I'm sorry?
Why?
It just takes a long time in Cyprus. It's all very time consuming.
What, to get recognition of his status in Cyprus? Has,
Well,
he,
and
made,
then to
has
have,
he made an application to be recognised in Cyprus?
my lord, no, but he doesn't need recognition in Cyprus. But what he does need to do is that's an oddity about Cyprus.
So he doesn't need
Sorry, Mr. Davis, how can he not? You have to explain why he doesn't need to take any action in Cyprus.
No,
The
no.
Russian court has determined that he owns, that the bankrupt owns shares in a Cypriot company.
Yes, Queeld and Myspare, that their position is that the Russian judgment has no effect in Cyprus. That's their position. They say that the Russian judgment, and this was the basis upon which they defended the Russian proceedings, the Russian court had no jurisdiction to make any orders in respect of the Cypriot company or in respect of its share register. They said it was foreign non-convenience. And the Russian trustee, my client, was going to move in Cyprus before he received notice by the advertisement of the English proceedings, of which he was previously unaware because he had not been told about them, despite the fact that he was litigating against Queeld in Russia. And so he responded to the advertisement and then sought to obtain permission from the Russian court to fund legal representation in this jurisdiction, and he encountered difficulties in that respect, which took time to resolve. That's been his problem as far as the delay between March and November of 2024 was concerned. And so going back to the circumstances prior to, and I should say that, I was about to say that Mr. Vesnin was told in December 2023 that the certificates would be released on around about the 5th of March 2024. That was the advert that he received, or the notice he received from Simmons and Simmons. And he then set about, in effect, responding to that by lodging an objection to the release of the certificates in the proceedings in the court below in this jurisdiction.
Do you say that if it was, let's say it was ultimately determined in this jurisdiction that yes, Queeld does own the shares, but we see that the Russian court has said that the shares in Eurasia are owned by Queeld, but the Russian court has said that Queeld itself is beneficially owned by the bankrupt. What would you be saying should happen then in circumstances where the trustee has not actually taken steps, for whatever reason, taken steps to secure control of Queeld?
Yes,
If the trial envisaged by that was settled by the Tomlin order had proceeded, it might just have determined that Queeld owned the shares in Eurasia and should receive the replacement certificate.
except that there was the finding of the Russian court that the UBO of Queeld was Mr. Ananyev, and that his rights in that respect had vested in my client.
Yeah, but that would be for the shares in Queeld.
Indeed, but also the
Or
control,
in whatever company is further above.
but also the control of Queeld.
Well,
No. Only, well, yes, if you get the shares in Queeld into your hands, you can then replace the directors.
Yes.
So you can, quote, take control. And
Yes.
my question to you a little while ago was simply, given that that's the order you had from the Russian court in 2023, together with an order that Mrs. Ananyeva should take necessary steps to register I think your client as the owner of the shares in Queeld, or get onto the register in right of Mr. Ananyeva. I probably haven't pronounced that correctly, but sorry.
I think you have.
Okay. Nothing seems to have been done to give effect to that Russian judgment in the jurisdiction in which it seems to be directed at.
And that's because the advice received by my client, I'm not waiving privilege, is that that cannot be done in the time that it is required. It'll take years. And what he's done is he's done the thing that the only thing he can do, which is respond in this jurisdiction to the advert to say, no, don't release them, the certificates to Queeld, because they will end up in the hands of Mr. Ananyev and to the detriment of the bankruptcy estate. Because his case is and always has been, and that was the fear of Eurasia, is that the real person behind Queeld and MySpare is and remains Mr. Ananyev.
But he's never made an assertion in the Russian court that the shares in Eurasia are part of the bankruptcy estate.
Well,
He's certainly not got he certainly hasn't got a judgment to that effect. As my lady's pointed out, he's got a judgment which might actually suggest that that isn't the case.
What the Russian court has decided is that he controls Queeld. That's the decision that the Russian court has made.
Well, not according to paragraph 129 of the Snowden you've shown us, so you'll have to show us the judgment in
Yes.
Russia. Because the paragraph 129 of the Snowden you just showed us suggested that it ruled that the shares in Queeld are part of the insolvency estate.
Yes, the judgment is in the respondent's notice bundle. And let's turn up the English. Sorry? Oh, it's in the supplementary. I'm so sorry. I've got the wrong judgment. It's tab 28 at page 370. And the disposition is at 380.
to include 100% of the shares of Queeld in the bankrupt estate.
That seems to be fairly summarised in paragraph 29, but it doesn't say anything about shares in Eurasia.
Yes, I mean, it was this judgment was on the premise that the assets of Queeld were the shares in Eurasia. And they referred to it throughout the judgment.
Well, but in which case the premise for this is that it's Queeld that beneficially owns the shares in Eurasia, not your client.
Well, I'm not clear about that, but I
You just said that, I thought.
well, own in the sense that the legal owner on the register, but as to whether that's on a bare trust for Mr. Ananyev.
In which case your Russian judgment wouldn't really help you, would it?
Well, the Russian judgment establishes that Mr. Vesnin has vested in him the beneficial interest of all the shareholding of Queeld. And returning then to the Tomlin order, the parties having identified, or Eurasia having identified various persons who might object to the release of the certificates, including the liquidator of Morendo and our client, Mr. Vesnin, the Q&M made it clear in their case before trial that Mr. Vesnin had not obtained recognition and would need recognition if he was to object here. It was a point they made in their trial skeleton. When they came to the Tomlin order, what Eurasia insisted upon in lieu of a counter indemnity was a mechanism whereby not just those two identified risks, but any other risks were fleshed out by an advertisement and brought before the court in order for their objections to be heard and determined.
Well, there's two separate points there, as I'm sure you're aware. Notification and then what happens next.
Yes. Yeah. And so far as that's concerned, if we can just look at the Tomlin order, which is in the core bundle behind tab 10, at page 163. The first page, 163, is in, I would suggest, standard form. And the action, as always, is in the schedule. So far as the schedule is concerned, you'll notice in paragraph 1 that the Eurasia had decided to exercise its discretion to, under Article 9.6, to issue the replacement certificates in the circumstances and on the terms set out below. So it was a conditional issue. And first of all, there were the mechanics for making the advert and delivering the certificates. That's paragraphs 2 and 3. And paragraph 4 was the issue of the certificates. At the end of the notice period, which was the 4th of March 24, if no notification was received at all, then the certificates were simply released to Queeld and Myspare. And that's paragraph 6. Otherwise, paragraph 7 applied, and this is what brings in the machinery. save as provided under paragraph 6.1, each of the claimants and the defendant shall be at liberty on and from the 5th of March to apply for such further directions as it sees fit, including any order as to disposal of the replacement certificates. And secondly, the claimant's solicitor's undertaking at 2 shall, save as may be agreed in writing between the claimants and Eurasia, remain in force until further order. And
Just pausing there, it did strike me as quite interesting that, of course, if you're right on your interpretation of this and the effect of Adam Johnson's decision, this mechanism effectively stays in place until the final resolution
yes,
of the dispute. But you could be stymied at any time should Eurasia decide to agree otherwise.
absolutely, and that's an important
So
point.
that's what 7.2 says.
And
Which is
Eurasia,
somewhat surprising, isn't it?
no, with respect, it's not, because Eurasia have always said, I want a counter indemnity or I want immunity, one or the other. And I don't get either this way.
Sorry, I put it wrongly. I don't mean surprising in the context of the Tomlin order, but perhaps more surprising in the context of the interpretation you wish to put on this as putting in place a mechanism to allow final resolution of a dispute between Queeld on one hand and whoever is coming along, whatever third party happens to come along in response to the advertisement.
We accept that had Queeld and Myspare issued a counter indemnity that was to the satisfaction of Eurasia, that they, subject to any intervention from my clients, they could have simply taken the certificates. The problem is they could not, and the reason they could not is because of the suspicions and previous dealings, which presumably over a 3-year period resulted in them being unable to find a bank or an insurance company to give the counter proposal, a counter indemnity. And those suspicions are all the ones that are set out in the trial skeleton arguments of Eurasia at some length. And really 7.2 in the order that we would, in the schedule that we were just looking at, is a sort of safety valve. Should Eurasia consider that the notices were wholly without merit, there was just no risk to them at all, because it's all about the whole thing is about risk to Eurasia, and the extent to which they feel there is risk. And we accept that it's in Eurasia's gift at any time to say, well, I don't think I'm any more I'm subject to risk anymore. The difficulty is, as we will come on to, as a result of the judge's order, which is under appeal, they are under considerable risk at the moment, which is presumably why they haven't agreed to release the certificates. And just to unpack that.
What is the risk?
Well, the judge's order has not given them any form of immunity.
You know, but from what? What's the claim against them?
The claim would be, and they have themselves articulated this in their skeleton argument, but the claim would be that they have wrongly issued the certificates, knowing on their own case that they're going to go to Mr. Ananiev in circumstances where he's bankrupt and his trustee is saying don't do so.
Okay, that doesn't. Can you answer legally what the risk is to them, as opposed to? I mean, that's just sort of. There's no. You haven't put a legal framework around that. What's the claim?
They have significant interests in Russia. They have themselves said it may well be that in Russia, Mr. Vesnin would issue proceedings in the bankruptcy court against Eurasia for wrongful.
What do you mean wrongful? I mean, give me a recognisable cause of action against them that I can get my head around.
Well, it would be, in effect, transferring the benefit of the asset to the bankrupt when it should go to the estate.
It's not transferring the benefit, it's issuing evidence of what's on the register of members.
I mean, if one goes to the trial skeleton of Eurasia again, which we looked at earlier, paragraph 9, I think it is. That's in the appellant bundle. think it's
Paragraph which, sorry?
it's page 37, paragraph 9, which starts 7th.
Thank you. Yeah.
And after a reference in the second and third sentence to the civil proceedings, he says, when Eurasia issues replacement certificates to the claimants, those presently in control of the claimants will be able to deal with the shares. They may procure the claimants to sell the shares and pay the proceeds away. If in fact Queeld shares in Eurasia are presently subject to an attachment, or Queeld itself is property owned by the bankruptcy estate, Eurasia may be said to have assisted in enabling the shares to be dealt with and disposed of in that way to the detriment of Queeld and the bankruptcy estate. They may give rise to a claim against Eurasia. It's not necessary to establish even as a probability that there would be a claim or that it would succeed. The possibility in itself is a risk. And that's what was being said going into the trial before Mr. Vesnin was, as it were, on the scene.
Although selling the shares and paying the proceeds away, in order to transfer title to the shares in Eurasia to a purchaser, you'd need to submit the share certificates for registration.
You would, but
Unless you had a purchaser who was completely stupid, they wouldn't pay the money until they had been registered on the register of members of Eurasia.
well, we
So
already
Eurasia would get another chance if it considered that there was some suspect transaction to refuse to register.
we already know that it is alleged that there has been a sale of the MySpare shares for several million pounds, I think it was, notwithstanding the absence of the share certificates, replacement share certificates. So there was a discount because of the absence of the certificates. So in other words, they realised a substantial sum, notwithstanding the absence of the
So you
certificates.
don't say that's a genuine transaction.
Well, we don't, but it is asserted to be. I mean, this is the sort of thing that Eurasia wants to avoid. It wants to cut it off, as it were, at the beginning before these opportunities arise. And it's always said so, to be fair to Eurasia. It regards Queeld and MySpare, certainly Queeld in this context, as just a creature of Mr. Ananyev. And it sees that Mr. Ananyev is bankrupt. And therefore it wants to avoid getting embroiled in any hostile litigation.
So you're saying the intent is that of the Tomlin order is that the shares will remain until every conceivable claim in relation to them, or indeed direct or indirect, has been resolved.
Yes, I do, but it's not quite as sort of awful as it sounds, because this is the exchange that took place when the trial, when the proceedings were compromised. Queeld and MySpare had been asked over several years to give an indefinite counter indemnity. They had failed. And so Eurasia came up with a means of a halfway house, as it were, by which it acquired immunity, it thought, in return for issue of the proceedings. Now, if those proceedings take 3, 4, 5 years, then that's a matter for Queeld to solve simply by issuing the counter indemnity. It's always that way out, but Queeld will not do so. And the fact that it won't do so is relied on heavily by Eurasia as indicating that no insurance companies in these circumstances are prepared to underwrite these risks, and that Eurasia itself will not take the risks either. And it's fair to say that the undertaking only remains in place for those who have come forward before the time bar. And for current purposes, that is only Mr. Vesnin and possibly NBT, but they seem to have fallen out of the fray. So it's not an open-ended free-for-all for potential objectors in the future. The time bar has been and gone, but Mr. Vesnin has got his objection in. And he now is probably the only objector in town, as it were. And on this question of delay, it is also right to say that Mr. Vesnin is surprised that he was litigating in Russia against Queeld and its legal representatives about the ownership of Queeld in proceedings where it was recognised that the only known assets of Queeld are these shares. But Queeld studiously avoided disclosing to Mr. Vesnin or the court.
Sorry, you say, sorry, can you just repeat what you just said?
Mr. Vesnin was litigating against Queeld in Russia in the proceedings which culminated in the October 23 ruling. Queeld were represented there.
Sorry, it was, you said what? It was known that the only asset of Queeld was these shares in Eurasia.
Yes.
Who knew that?
That's, at all material times, no one has ever suggested that there's any other asset, even today.
Well, that's the point we were on earlier. Has anybody actually suggested that these Eurasia shares are owned by anybody other than Queeld?
Everybody is proceeding on the basis, other than Queeld and Mice there, that Queeld is a bare trustee, it's a nominee.
That's different. That's different from what you just said. That's why I picked you up.
Ah, sorry. The only asset in the sense that they have the legal title, it is thought that they hold that title for the ultimate beneficial owner, who it is said to be Mr. Anania.
That's complete, with respect, that is completely different from what you said.
I'm sorry. They are, in that sense, I mean, that's my fault. I mean they are the legal owners. That's not in dispute of the shares in Eurasia.
Well, everybody knows that they're the legal owners of the shares in Eurasia. The question is, who's the beneficial owner of the shares in Eurasia?
Yes. Mr. Vesnin has not had any disclosure. He doesn't yet know what it looks like. He has said throughout, as far as I can see, the only asset registered in its name is these shares. But at this stage, he's not received the disclosure that Eurasia received in the main proceedings. He's been given nothing. And what he wants, of course, is to have disclosure, and then he can decide in an informed way what his case is in this respect. But at this stage, he is entitled to say that he has the Russian ruling, and as far as he is concerned, all the indications are that Queeld acts under the direction and for the benefit of Mr. Ananiev.
Okay, I'm still waiting to be shown any evidence to support that latter proposition. It's not in the judgment for reasons that we explored.
That Mr. Ananiev is the ultimate beneficial owner.
No, that Queeld holds the shares in Eurasia on a bare trust as nominee for Mr. Ananiev.
Yes, all I can say is that it has been said time and time again that that Queeld appears to have no other function other than to hold these shares. And that
doesn't mean that it can't own them beneficially. That happens all the time.
I agree, my lady. I do agree.
So that I think that's what we're struggling with.
Well,
there is a difference between holding the controlling strings,
yes,
in telling the directors what to do, for example,
yes,
and actually showing that you beneficially own the shares held by the corporate vehicle.
I respectfully agree.
That is obviously different when we've got Cypriot shares, and our jurisdiction here is very much focused on English assets.
Yes.
So we, and the Russian judgment doesn't, and we have to accept, talks about the ownership of Queeld. It doesn't talk about the ownership of the Eurasia shares.
No, it doesn't. And all that has been happening to date is that Mr. Vesnin has been trying to gain voice in these proceedings so that he can participate. That's where we've reached.
But it is at one step, if what I've just said, if you take the Russian judgment at face value, any participation he has has got to be one step removed. He'd have to persuade the court, yes, okay, it doesn't matter if I don't directly beneficially own shares, but I am the controller, and therefore you should essentially listen to me.
And Mr. Justice Adam Johnson's judgment.
I know I've read it, and he says the real dispute is over, or words to this effect,
Yes.
is over the UBO. That may very well be right, but it
Yes.
doesn't quite deal with this point that we're talking about.
No, I accept that, but in the sense what he was dealing with, it was at the threshold, seeing whether the claim which is put forward by, or the interest put forward by Mr. Vesnin is one which triggered the Tomlin order machinery.
That's all he had to decide.
And he then gave directions for the resolution of that issue. And the problem was, if I can just jump ahead, is that he was given a consent order by the parties with a relatively speedy set of directions culminating in a 2-day hearing in what became November of 2023 for the resolution of that issue. He was not told that Q&M intended to mount what became an estimated 5-day opposition of the recognition of Mr. Vesnin in this jurisdiction to enable him to be heard in that dispute. And that is the core problem, that the directions were given not as a result of a discussion in court about the nature and extent of those directions, but just the parties gave a time estimate of 2 days for the final resolution of the issue in circumstances where clearly Queeld and Myspare intended to fight tooth and nail recognition, which they ended up later in the same year saying would take 5 days. And they have always said that Mr. Vesnin could not be heard properly prior to recognition. That was a bit of a wrecking ball in the directions which Mr. Justice Adam Johnson was asked to give when the draft consent order was put before him.
When you say consent order, obviously there'd been a disputed hearing over
Yes.
presumably over the principle
Yes.
of whether the dispute, the mechanism in paragraph 7 or whatever it was, had been invoked. But then, as is often the case in the interims court, the consent was presumably the parties went away to agree the directions.
They did. I mean, he very sensibly, as you say, and he very sensibly sent them away, and they, days later, I think, came up with a draft consent order. Again, Mr. Vesnin has no visibility on any of that. But the consent order itself, you'll see it's in the supplementary bundle at 213. In the recitals on 213, in the fourth recital, or fourth or fifth recital, he defines the issue as whether the undertaking should be released. At the top of 214, the last recital records that the provisions of the order were without prejudice to Q&M's entitlement to challenge the standing of Mr. Vesnin and or NBT, and do not constitute a waiver of entitlement. And then he dismissed the application for release that was before him, and the operative part of the order is lifting the stay at 5 for the purposes of determining whether the undertaking should be released on a subsequent date. And then at 6, he joined NBT and Mr. Vesnin on a limited basis for the purposes of deciding whether the undertaking should be released, and made some direction that they should not be entitled to production of various other documents. And then the time estimate is at paragraph 9. And he was not told that recognition was going to become as it were, a state trial, and that cross-examination would be needed, or anything of that nature. And he simply regarded, as entirely understandably, that as the parties' agreement as what was required in order to get the issue determined. And just if we go back in the same bundle, 2 tabs, tab 7, page 70. I appreciate my lord and my lady read this. I'll just briefly remind you that before him had been, learning from Mr. Harrison, now before the court. Mr. Margolin was for Queeld and MySpare. And Mr. Cruz appeared for NBT. My client had written a letter to the court. And could I just invite you to look at page 73 at 4.4 of the note. Mr. Margolin submitted that when looking at the Tomlin order, it's important to have regard to the facts that gave rise to it and why they were there. And then he referred to 2 documents, the trial skeleton argument of Mr. Harrison and the witness statement of Mr. Sushjov, both of which were not before Mr. Morgan in the court below and are the subject of the fresh evidence application. And at 4.5 over the page 74, Mr. Margolin submitted that these documents were important in terms of understanding not only why the claimants made this application, but also the purpose of the settlement. And Mr. Harrison said the same thing in his submissions in relation to his trial skeleton argument. And as my lady has already mentioned, when we go down to 4.9, we see the first occasion when the judge says that the question here is who is entitled to make a claim over the shares as the UBO of MySpare and Queeld, which gives rise to an indirect interest in the shares of Eurasia. And he goes into Mr. Vesnin's position. At 4.15, basically Mr. Margolin submitted an A that Mr. Vesnin had not been recognised, and that was a problem. And then he questioned the liability to which Eurasia was exposed, as far as Mr. Vesnin was concerned, to B. And again, over the page in 5, the submissions of learned friend Mr. Harrison on behalf of Eurasia, it's B that's largely relevant. So far as Mr. Harrison and Eurasia were concerned, it's the second sentence. He wanted to make sure that the third sentence, that the certificates were issued in effect to the right people, correct people in the next paragraph, recognising that Q and M are likely only to be nominee offshore vehicles. And it's there that at the end of that paragraph he submitted, in accordance with his skeleton argument, which is in the bundle, that Eurasia was in a similar position to that of a stakeholder under CPI 86. And then he mentions DENAX and the proper opportunity to participate, and that's because Eurasia wanted to argue some form of immunity from suit on a Henderson basis. And then he refers to his trial skeleton argument at D. He says, CH's trial skeleton set out in detail the concerns that Eurasia had, which is precisely what led to the process set out in the Tomlin order. And there was then various discussions, and finally at 5.9 on page 78, Mr. Harrison summarised his client's position. They were looking for directions from the court in order to resolve the dispute. And the ruling starts at 6.4, and at 6.4, the judge records the fact that he had two applications before him, one for the release of the undertakings in respect of the holding of the share certificates, and the other was an application for an adjournment made on behalf of NPT. He said that both of them, 6.5, resulted in essentially the same core question, the proper construction of the terms of the Tomlin order. And then he said again, as he had in 4.9, the point seems to me to rise in this way, focusing on the positions of MySpare, a BVI company, and Queeld, a Cypriot company. It is said that the UBO is in fact a Russian individual, Mr. Ananiev, and or his wife. This explains the interventions in this action by two parties. And then he goes into each. He describes again Mr. Vesnin at A in the last sentence as having an indirect interest in the shares in Eurasia. And NBT's position is also summarised at B. And
is the letter that is referred to in 6.6a somewhere in the bundle?
no, I don't think it is. And I'm not sure that I personally have seen it.
Well, it's your client's letter.
I know it is.
Dare say that you could procure a copy.
Yes, I'll do my very best. At 6.7, it's the sort of operative part of his ruling, really. He says, it seems to me that resolving these questions requires interrogation of the meaning of the Tomlin order. He says, it seems to me that the language of any claim to or interest in those shares in the advertisement is essentially very wide. When looked at in the context of the machinery in paragraphs 5 to 7 of the schedule, I take the view that this is not restricted to presently subsisting legal or beneficial interests. It seems that the overall machinery was designed to invite expressions of interest in a more general sense from third parties who might wish to engage. The gist of the machinery was to say to third parties, if you want to argue that these certificates ought not to be released to the claimants, so that those presently standing behind the claimants can deal with them freely, you should say so, and if you say so, further direction should be given as appropriate to resolve the expression of interest in the certificates. And then he goes into how the machinery works. And again in 6.9, he stresses that Mr. Vesnin's interest...
You gloss over 6.8, but the machinery is that further directions be given and the undertaking would remain in force until further order of the court. I mean, he's reflecting the wording in the document. I mean, he's not saying that the undertaking couldn't be released.
No, I absolutely agree with that, my lord. And then at 6.9, he says it's correct to say that Mr. Vesnin's interest in the shares is indirect. And he deals with NBT at 6.10. And then finally, he says as a matter of general discretion, as a matter of principle, I referred to commentary in G. It's clear that jurisdiction to release the undertaking must also be discretionary and good reason must be shown for releasing it. I agree with this, and it seems to me that the proper exercise of discretion lies mainly in favour of keeping the status quo. I think it would be a mistake to make effectively a peremptory order today, which in effect would be determining possibly on a final basis the competing interests in the shares.
How going back to the point I made earlier, when is this right? You say that there is a risk that if the share certificates are given to or are issued to Q&M, that the shares in Eurasia will be able to be dealt with by those in de facto control of Q&M.
Yes.
And how would that, just looking at the end of 6.9, immediately free to deal with, and they will be taken out of the bankruptcy estate. I mean, they can't be taken out of the bank, they're in the bankruptcy estate. Your claim presumably would be to follow the shares, assuming the shares in Eurasia are in the bankruptcy estate, you'd have to seek to secure or to get hold of the shares.
Yes.
And you'd come to this jurisdiction if you established that the shares in Eurasia were in the bankruptcy estate. They're registered shares in an English company.
Yes.
And so you'd come to England and say they belong to me.
Yes. But Mr. Vesnin hasn't gone that far. What he has said that he has become the de facto controller and owner of Queeld. That means also.
That's another route which could stop them being dealt with inappropriately, but he's chosen not to pursue that.
Well, my lord, he thought he was pursuing it by responding to the advertisement.
Well, no, he's not pursued the other route, which is to get control of Q&M.
Yeah, but he can't do it in time.
Well, so you say, although he's, in fact, if time was a problem, getting on with it would seem to be at least a first step in the solution. He just seems to have said, I'm not going to do it.
Well, my lord, he hasn't. I think, with respect, what he has done is concentrated on the fact that the advertisement has been received, and he's responded to that.
He's not done anything to try and get control of Q&M and to follow up on the default of Mrs. Anyanova in complying with the Russian court order.
Not as yet. No, he hasn't. He would, no doubt, have done had it not been for what's happened here. He has responded in this jurisdiction to the advertisement and come to this court, and he had to go to the Russian court to get authority to take funds from the bankruptcy estate in order to fund this opposition to the release of the undertaking. And one can see that from his point of view, the safest route is to have his argument out in this court before the genie is let out of the bag and the certificates are effectively delivered to Queeld and Maisper to do with them what they will.
But to succeed, wouldn't he not ultimately have to persuade this court to treat him consistently with what Adam Johnson is, Mr. Justice Adam Johnson is saying, which is indirect ownership, not direct ownership. If consistently with that, he'd have to persuade this court, treat me, the trustee, as the owner of the shares in Queeld, therefore disregard the existing directors and controllers of Queeld and deliver the certificates to me. Wouldn't he have to persuade the court to do that?
Or
why wouldn't the court say exactly what my lord is saying?
Or do not release them to Queeld and Maisper.
Even though on this premise, Queeld and Maisper are the actual owners.
The certificates only exist because, having failed to give the counter indemnity, this machinery was put in place to flush out these claims. So Queeld and Maisper, in that sense, are lucky to have any certificates at all, because they knew that they may well have lost at trial, because Eurasia was entirely within its rights to say, we're not happy exercising our discretion in this way. So the certificates would never have come into existence. And so Eurasia then could have, unfortunately for Eurasia, have been in a position where it was on the receiving end of all sorts of people saying, I want you to either deliver them to us or be involved in proceedings where that dispute is determined. And that's what Eurasia wants to avoid. It wants to have nothing to do with it. And that's what it thought it was achieving by the Tomlin order, by getting everybody in the corral, getting everyone joined who wants to challenge, and then getting a binding determination as to whom, if anyone, the certificate should be released.
Did the letter, I mean, I do want to see, if I may say, the letter that was written in response to the advertisement by your client.
Yes.
And it'd be useful to understand what it said, because at the face of Mr. Justice Adam Johnson's judgment, it says in the letter, Mr. Vesnin has sought to claim an interest specifically in Queeld. It most definitely does not appear to say that your client claimed in response to the advertisement that it had a beneficial interest in the shares in Eurasia.
I think, just like Eurasia, it is operating on the basis that Queeld is a mere nominee offshore vehicle.
Well, that's just not what it says.
Well,
And that's why I want to see the letter, because on the face of it,
yes.
it doesn't seem to say that. It seems to say precisely the opposite, which is that Queeld owns the shares and your client claims an interest in Queeld, which leads to the question of why haven't you gone to the jurisdiction in which Queeld is incorporated to assert and gain control through that route and avoid, you see, because what your suggestion is that this order has put in place an unlimited, open-ended protection against any and all proceedings which may relate to these shares in this jurisdiction, in circumstances where, in fact, your client may not have been claiming an interest in these shares at all, but is claiming an interest in shares in Queeld, which it should be vindicating in another jurisdiction. It's a very odd, if I may say, interpretation of what the order should substantively should achieve.
Well,
if in fact your client is not claiming the shares in Eurasia.
My Lord, Mr. Justice Adam Johnson found that this indirect interest, as described in his judgment, did come within the meaning of the Tomlin procedure, and that there should be a resolution.
The notification part, but not necessarily. Why should it necessarily follow that if your clients say, "Well, we have a commercial interest in these shares because they belong to a company which we have been held by the Russian courts to own, but we just can't get control of it at the moment."
Yes, ultimately.
Why should the Tomlin order, in a sense, provide you with an open-ended?
Because that's what the parties agreed in circumstances where Eurasia does not want, at the end of the day, to be on the receiving end of a claim by the likes of Mr. Vesnin that those certificates should not have been released in the knowledge that, of the bankruptcy of Mr. Ananiev and the ruling of the Russian court.
But if, okay, right.
And in the end,
Does somebody in court have that document?
My Lord, it's supplementary to tab 44.
yes, that's not the letter, I'm afraid. That's the letter that Mr. Vesnin writes to. It's not to the court.
Now, I'm looking for the.
This is after the
Yeah,
cut-off date. We're looking for the letter with the cut-off date. There are files and files of what seem to me to be totally irrelevant documents. But the letter that Mr. Vesnin wrote does seem to me to be a relevant document. There are about 24 people in court. Does anybody have a copy of it?
I mean, that is the letter that's being referred to. It's the letter, is that right? The letter that's written, that the judge is referring to at 6.6a.
Yeah.
It's the one in response to the advertisement.
Yeah. So it's got to be before the 6th of March. Because
It says, let me explain briefly the nature of their interests which have been expressed in their communications sent to the parties in response to the announcement. And then he refers to a letter. And I just, why is that not amongst this forest of papers we have?
Yes, it was a letter that was sent whilst Mr. Vesnin was a litigant in person, and I'm afraid we will try to dig it out. But certainly,
Was it a letter to the court?
I think it was.
No, the letter to you, letter to.
It's a letter to
because it's got to be from.
Yeah, Eurasia should have it. It would have been sent to them.
If it helps, and it may not, in the supplementary bundle at 235, the letter is summarised. This is within the witness statement of Ms. Duncan on behalf of Q&M in support of the application that was before Mr. Justice Adam Johnson. In paragraph 9.
Sorry, 235.
235, paragraph 9.
Sorry, of which one?
Supplemental.
Supplementary. paragraph 10 is the summary, I think. To answer my Lord Justice Snowden's question, I think the one that Mr. Justice Adam Johnson was referring to is paragraph 14. That's the 6.6a.
Sorry, this letter is the one from the 28th of February, we were looking at before.
But my lady, I think paragraph 14 is probably the letter. It's Mr. Vesnin's letter to Simmons and JHA.
So I'll just put the bundle away. So where are we again? I've lost it.
I'm so sorry, it's 236 in the supplementary bundle behind tab 15.
5th of March was too late though, wasn't it? Didn't you have to respond by the 4th of March? So,
Yes, he did on the 1st of March, and I think the speaking letter was on the 5th.
yes, but, sorry, just go back to paragraph, I'm probably behind. Paragraph 9 on page 235. By email on the 1st of March, he sent a letter dated the 28th of February to Simmons and Simmons.
That does seem to be.
That is the letter that we've just been taken to later on in the supplemental bundle. That one is at tab 44. It's the same letter, isn't it? Is that not the letter, the critical letter? So at page 648, the shares in Queeld are owned by Miss Amenuva, are included in the debtor's bankruptcy estate, etc.
The foot of 648 is on the basis of the foregoing, I must inform you and declare that shares in Queeld as owned by Miss Amenuva are included in the debtor's bankruptcy estate in their entirety. Therefore, no corporate decisions of any kind emanating from Queeld, including those which concern Queeld's shareholding in Eurasia, can be taken by any person other than myself. This in turn renders any transaction involving the aforementioned Eurasia shares potentially invalid and void, and as such, any relevant action purporting to be taken on behalf of Queeld by any person other than me is void, as contrary to my exclusive rights and powers vested under the Russian bankruptcy law in respect of the debtor's property. And there's reference to my spec.
Okay, so as I understand it, that's saying that if, for example, Queeld, having received the replacement certificates, ordered to sell as directed by its current directors, the trustee is saying, no, that is void because the shares are being sold at the direction of someone other than the trustee.
My lady, that's why Mr. Justice Adam Johnson was concentrating on the UBO issue. And it's just looking at the commercial reality.
Sorry to rise, my lords. I was obviously at that hearing in March last year. I've also found an email from Mr. Vesnin to the court at about 9 o'clock on the morning of the hearing. I'm afraid I can't forward that. I have it in an email with a privileged comment from my solicitors, but we can dig that out over short adjournment and provide copies at 2 o'clock. That would be helpful.
Obliged. May I turn to the judge's judgment? which is in the core bundle at tab 5, page 57. And in the first 45 paragraphs, he sums up the background and explains the need for the counter indemnity on the part of Eurasia and the fact that it didn't get a counter indemnity, or at least a suitable one, offered. And at paragraph 46 on page 65, we found that the primary purpose of the undertaking was to protect Eurasia. And one can detect within the scheme of the Tomlin a secondary purpose of providing some protection to potential third parties through the announcement mechanism and follow-on provisions if a claim or interest was asserted. This can be seen as part of the bargain between the parties. The court had a role in giving effect to that bargain by agreeing to give directions and, if appropriate, resolving issues between the interested parties. And at 47, he said, it's clear that third parties were given a short period in which to come forward and assert their claims. It also seems to be that the parties to the Tomlin order intended that any application for release necessitated by the assertion of a third party claim would be resolved expeditiously. That flows from a short period given to third parties to come forward, the fact that the shares were valuable and could not be expected to be tied up for a prolonged period, the holding of share certificates being a de facto prohibition of any dealing with them, particularly without any protection for the claimant, and the fact that both parties who had sought to end their dispute with the Tomlin order were entitled to expect finality in relation to residual issues rather than open-ended retention. And he then goes into, he recites Mr. Vesnin's letter at paragraph 51. I think that's the passage that I just read out. He then cites passages from Mr. Justice Adam Johnson's judgment at 52, and the crucial paragraph 6.7 from the Simmons and Simmons note of the judgment at 55. And at 60, he refers to the Denax principle. He sets out passages from my Lord Justice Snowden's judgment in Denax, 132 to 135, culminating in 135 in the statement that beneficiaries and creditors have the opportunity to attend and be heard. So this was all by analogy, and all, as my Lord has said, just arriving out of the commercial deal that was struck in the Tomlin order. And then he basically said that Mr. Justice Adam Johnson envisaged that there would be a final determination of the issues between the parties at this hearing.
I don't want to get distracted again, but it is important. 61, the primary function of the Denax jurisdiction being to provide a determination giving rise to an issue estoppel. Do you say that's right?
It's the primary function of the Denax jurisdiction being to provide an immunity for the trustee stroke office holder.
I thought that's what I had decided was not the case.
Well,
unless you have a full-blown trial, in effect. I mean, that's the problem with what had become the Denax jurisdiction.
Absolutely.
Was misunderstood.
Sorry, that's my fault. I misunderstood my Lord's question. Mr. Justice Adam Johnson and the judge were proceeding on the basis that Eurasia required immunity, and that's why they agreed the Tomlin order in the terms that they did. And he is here simply summarising what one might get out of.
I thought the point I made in Denax is if you want immunity, in inverted commas, not a word that I liked, right? You have to define what you want it from, and you'll only get it if, in fact, you, as the court, can conduct, in effect, the investigation that would be necessary to try the issue that would give rise to an issue of estoppel and hence immunity. And the point being that the sort of claims we're talking about here that involve somebody asserting that they have or may have an indirect ownership interest through a Russian bankruptcy and Cypriot offshore companies to these shares ain't going to be resolved anytime soon, quickly, or even potentially in this jurisdiction. How can it sensibly be said that trying those issues out was what was in the mind of the court or the parties when the Tomlin order was made?
Because that's precisely, in effect, what Eurasia had been saying throughout, that I do not want to release these or create these certificates if there is a danger that I'm going to be sued and lose money. And so please give me a counter indemnity. When that was not forthcoming, they came up with this mechanism expressly saying that it was by analogy seeking immunity through the DENAX principles, getting everybody into court.
If the court had been asked to decide whether that was legitimate use of the court's resources or would give rise to an indemnity, the court would have said, no, it's not.
Well,
How can DENAX and the parties, by a contractual arrangement between themselves, sort of bootstraps themselves into a position that, if asked directly, the court would not have entertained?
well, it isn't quite as awful as it sounds, because in fact what has happened is Mr. Vesnin has served his statement of case, his defence. That's now in the bundles, and a reply has been served with a view to resolving the very issue that we're talking about. And that has happened since the proceedings in the court below, and those pleadings are now ready for a CMC and directions for trial. It's not the end of the world, as it were. It's a dispute which is fully pleaded and will be won by one side or the other. So we are, in a sense, waiting to proceed.
So, again, it's not clear. It may just be me, and I apologise to my colleagues if they've...
It's not clear to me either.
Okay, well, there we go. So those pleadings are where?
So you'll find those in the respondents' notice bundle. The defence is at 110. Tab 3, 110. Yeah, 110.
Sorry, the respondents.
The respondents' notice bundle.
Tab 3, my tab 3 starts at page 54 with a skeleton argument. So,
Yeah, I think
And then they-
bundles have been put together. So, I think it's
Oh, it's
page
tab-
1,
it's tab 5, in fact, yeah, sorry.
3.5.
Yes. Tab 3 is subdivided. And so it's sub-tab 5, page 110.
Electronically, it's 131.
So this followed Judge Below's decision. Can you just talk us through what's happened?
It was Chief ICC Judge Briggs who gave directions on the 17th of January 25, and you'll see that at the top of this document, for pleadings in the action below.
This is in the Eurasia
Yes.
claim still. What's the separate claim?
No, so this is in the Eurasia proceedings. He directed that Mr. Vesnin serve a defence, and that's what is at 112. Oh, I'm sorry, 131, and also that a reply be served, and that's at 153, the full pleadings, and the next step is CMC with a view to.
Sorry, just give me the reference to the reply again.
The
I've
reply
got
is
the
at
defence at page
153.
1.
Yeah, well, it's electronic 153. My bold impagination at the bottom right-hand corner is 132.
Yeah, 132. We don't live in a world where the electronic pagination is ever the same as the paper pagination. But yes, so 132 is the reply from the claimants to that defence.
Yes,
And that's dated
21st of March.
Yeah.
24/8. And in effect, the defence sets out Mr. Vesnin's case as to why the undertaking should not be released. And the reply is a response to that in the usual way. And the judge directed a CMC in the near future. I'm told that the CMC is the first available date off the 2nd of May. The order where that was directed is in supplementary file tab 13, page 221.
So your case, in essence, is this is the dispute that you'd like determined in the normal way as soon as possible.
It is.
I mean, that's what you want.
And just, this may be obvious to everyone else, but I'm going to ask it anyway. Can, in terms of how this fits in with Mr. Morgan's decision and order, he's obviously not preventing this process happening, but he's not giving you the interim relief, if I may put it that way, via the Tomlin order. Is that the real issue?
On the day when we were due to move an application for interim relief, this court, Lord Justice Arnold, granted a stay pending the outcome of this appeal.
And you maintain on this appeal that you don't need to apply separately, effectively, for interim relief, because you can just continue the stakeholder arrangements for the replacement shares.
Precisely so.
If there was normally an interpleader where ownership was to be disputed between two parties, the stakeholder of the interpleader drops out and the litigation is carried out between the two rival claimants. If one of them wanted to stop something which would in the ordinary course of events happen, they'd normally need to ask for some sort of relief to stop it, wouldn't they?
That's where there's no Tomlin order in the first place, giving rise to, I mean, we say that the structure of the Tomlin order is such that it anticipates that everything will be dealt with within the machinery in the schedule. And that's just bringing everybody into the corral and resolving the disputes. And it is on that basis that the undertaking remains in place until that happens. And these pleadings, we say, should be allowed to proceed to trial under the Tomlin order with a result, one way or the other. Returning to the judge's judgment, which I think I'd reached paragraph 62, which is the crucial reasoning in his judgment. Paragraphs 62 and 63 are really where all the action is in terms of reasoning. In paragraph 62, he says, of course, if the nature and scale of the issues or the state of the evidence is such that it is not going to be practical or appropriate for the court to try to make a final determination of these proceedings within the confines of a 2-day hearing without cross-examination, then the court would be placed in the position of deciding how, in the interests of justice, and bearing in mind the purpose of the undertaking, it should proceed. If a final determination could only be made in other proceedings, then the court would need to consider the nature of the proceedings, the stage they were at, the merits insofar as ascertainable, and all the circumstances in deciding what was just. However, in my judgment, it was not the purpose or function of the Tomlin order mechanism as put into effect by the directions given by Mr. Justice Adam Johnson, which included expedition, for the undertaking to remain in place indefinitely pending resolution of separate proceedings without any protection being afforded to the claimants, as will be commonly found in a freezing order. In particular, a cross-exec undertaking and damages. That, in my judgment, does not reflect the primary purpose of the undertaking, which was to protect Eurasia, and for the court to consider the interests of the other parties to those proceedings. In my judgment, that would be a very different scenario. We say there's 3 errors in that paragraph, and I'll read the next paragraph before going back. There's a 4th error in the next paragraph. In the absence of a final determination of legal rights, creating an issue of estoppel upon which Eurasia could rely, the release of the certificates to the claimants by order of the court would provide it with an alternative form of protection in this way. A third party could not subsequently complain that Eurasia had done anything with the certificate that caused it loss. On the contrary, the release of the undertaking would be as a result of the court order. Now, I did not understand Mr. Davis to advance an argument to the contrary. If he did, I reject it. The concern of Mr. Justice Adam Johnson at the stage before him was as to Eurasia's position. It was simply required to release the undertaking under paragraph 6 of the schedule. The present position is quite different. Dealing with that last paragraph first, with respect to the judge, we do say that he wrongly considered that this order that he was going to make to release the undertaking would provide Eurasia with some protection. I mean, it plainly does not. And we've sort of gone into the...
Okay, can I just understand that a little better? Because at this stage, Eurasia has actually, under the terms of the Tomlin order, it's actually issued the replacement certificates. They've gone to some solicitors who are holding them. Can Eurasia really is it really at risk of being criticised if a court then permits those solicitors, who are not Eurasia's solicitors, to release these share certificates, which Eurasia has already issued under the terms of the Tomlin order?
And my lady, it's not so much whether Eurasia can be criticised. The question is whether someone in the position of Mr. Vesnin is prevented then subsequently from making a claim against Eurasia for the wrongful release of the certificates.
That's Eurasia isn't releasing them.
Well, in effect, it is, because it's put in place the Tomlin order, and the question is whether on any abuse process, Henderson type issue of estoppel, my clients have had a full opportunity in these proceedings to have their issue determined. They will not have done under the judge's regime, and therefore they are not prevented from suing Eurasia in due course.
So on that basis, Eurasia should have been standing up in front of Mr. Morgan and saying, please don't make that order.
Yeah.
That's a jury report. But it follows logically, doesn't it?
Well, Eurasia's position was always that it's as a stakeholder, that it was neutral. I don't know whether it thought that it was going to get its immunity by dint of the judge's order, but I am entitled to submit, I think, that it is not. Because there's no version of Henderson which would entitle somebody to prevent me from issuing separate proceedings simply because the judge made the order he did.
Mr. Davis, it would help me. You said that there were 4 errors, 3 in paragraph 62 and 1 in paragraph 63. Can you just very briefly identify those?
Yes, in paragraph 62, the judge, his first error is that he seemed to believe that the only way in which a final determination of my client's challenge to the release of the certificates could be made would be in other proceedings. And those other proceedings are the recognition proceedings. And he's just wrong about that with respect to him. Because the pleadings that have subsequently been served in these proceedings make it clear that subject only to obtaining recognition, which Mr. Vesnin, subject to tomorrow's appeal, has obtained, these proceedings are the vehicle for determination of the dispute. And for some reason, the judge thought that only in the recognition proceedings could that be determined, and that was just wrong. So that's the first of the three errors in paragraph 62.
Yeah.
The second was that he talked about the undertaking remaining in place indefinitely, pending resolution of separate proceedings. Well, first, it's not pending resolution of separate proceedings, and secondly, it's not indefinite. It's only until the end of the trial in respect of the issues that are now pleaded. And it's in these proceedings, as it were, in the court below. And his third error is that he seemed to think that the Tomlin order, that the purpose of the Tomlin order included a purpose to protect the claimants, which, with respect to him, we would say it emphatically was not. The purposes that the judge had earlier found were in paragraph 46, primary purpose to protect Eurasia, secondary purpose, the protection of potential third parties. When in paragraph 62, he starts to talk about the protection of Q&M, we say that he goes too far, and that's...
Is that where he's saying the court to consider? You're talking about the words near the end, are you?
To consider the interests.
For the court to consider the interests of the other party, the claimants. Well, Tomlin order is a compromise between those.
It was, but the question is whether the purpose of the Tomlin order included to ensure that Q&M would be protected against delays in the release of the undertaking. And we would say that nothing in the Tomlin order supports the contention that the objective intention of the parties was to afford protection to Q&M.
The judge says it is. Is that the penultimate sentence of paragraph 62?
No, I think it's further up.
Without any protection,
Without any
being
protection
afforded
being
to
afforded.
claimants, as will be commonly found in a freezing order.
Because he's talking there about protection of a different sort.
Well, my lord, as I read it, he's saying if this goes on for too long, they are unprotected because they don't have a cross-taking damages.
Well, he's saying you're trying to achieve, through your interpretation of the Tomlin order, a situation where you don't have to actually seek an injunction to stop somebody dealing with assets which you say they shouldn't be dealing with, for which you would normally have to give a cross-undertaking in damages.
And our point is that the Tomlin order does not have as its purpose, and there is no provision in there, to suggest that there is any such protection contemplated reasonably and objectively by the parties, because of course they would have said so. So in fact it's the contrary, that the certificates were only procured on the basis set out in the Tomlin order. They're only come into existence on the basis of the Tomlin order. And there's no mention in the Tomlin order or in the announcement.
So that the certificates are issued, held in some sort of escrow by the solicitors, pending release from the undertaking.
Yeah.
I thought the point that's being made, I thought it was made against you, which is you shouldn't construe the Tomlin order in such a way that enables you to put a blanket prohibition on anything happening to the share certificates without you having to give a cross-undertaking in damages, which is what you would normally have to do if you try and stop people dealing with assets to which on the face of it they're entitled.
And the answer to that is, just as in interpleader proceedings, you don't have one side or other side giving undertaking in damages. You simply decide to whom the certificates should go, or whether they should go. You don't cherry pick one side or the other for protection. And we suggest that there's nothing in the Tomlin order that singles out Q&M for special treatment or for any special protection. And had they intended that, then they would have stipulated for it. Because after all, this was a consensual deal.
And then the error in 63, the fourth error?
that is that the judge seemed to think that by ordering the release, he would provide protection to Eurasia, which he did not. Whether under Dynax or otherwise, by analogy.
You still don't actually claim that you own the shares, do you?
We can't until we haven't had disclosure yet, and so we.
But if these pleadings are resolved, the issue that will not be determined is that you own these shares.
My lord,
You're all it said is they ought not, for some reason, to be delivered to the Q&M because of some claim that some alleged wrongdoing that they might perpetrate. But you don't, it's not actual interpleader proceedings, it's not actual stakeholder proceedings. You don't actually claim that you own these shares.
well, it's always been said it's akin to stakeholder proceedings in the sense that Eurasia drops out.
Yeah, but if you were saying, I don't own these shares, but they shouldn't be dealt with by the people who on the face of it do, because it may constitute some wrong to me, you would normally need to formulate that, and if you wanted to injunct that, you need to give some sort of cross-undertaking damages. And
We say we wouldn't have to give any cross-undertaking damages because we're simply coming to this court effectively by invitation to challenge the release. That's the question is, should these certificates be released? Does anybody object? We object. On what grounds? And then we set it out. That's if you like, the issue. Do you object to the release of these shares to these persons? And the answer is we do. And then the question is whether that objection is upheld. And we have always said that that is the issue, and it is the question which arises out of the Tomlin order and for which the Tomlin order provided the machinery for the final determination.
so you're expecting, are you, the English court will resolve the question of who's entitled to control Q&M?
And we do, and that's precisely what Eurasia anticipated in its trial skeleton, and that's what Eurasia gave the opportunity to the likes of Mr. Vesnin to come forward to state. That's always been the position. Do you resist the release of these certificates in these circumstances to Queeld and Maisper? And Mr. Vesnin says, yes, I always have. And to come back to my Lord Justice Coulson's question about paragraph 63, we think that the fourth error of the judge was to believe that in some way Eurasia is protected by simply now releasing the certificates to Q&M and those who presently stand behind them.
I'm not sure I fully followed the last sentence, penultimate sentence of paragraph 63. Mr. Justice Adam Johnson was dealing with an application to release the shares. And either he would have done or he wouldn't. But if they had been released, there would have been a court order. So I'm not quite sure why he says that his concern was without the protection of a court order. It doesn't seem to follow. Q&M wanted the shares. He said no and made the directions that he did. So if he'd said yes, they would have had a court order, and therefore I'm not quite sure I understand why that was his concern, why the judge says that was his concern. Anyway, it's probably not critical point. All right, so those are the 4 errors that you identify in 63 and 64.
They are, and then those errors feed into his disposition in paragraphs 90 to 93. You may recall that in paragraph 90, he sets out what he considers to be the 3 options that were before him. Simply release immediately.
Yes, I mean, those feed into the first sentence of 91. In my judgment, option B does not accord with the purpose of the undertaking, not in the interest of justice.
Yes.
And that effectively you could have in a paragraph for the reasons set out in 62 and 63. Yeah. Yeah.
And so we, in the round, we do say that the judge wrongly characterised the purpose of the Tomlin order and made those 4 errors. And that based on those errors, he went for his option C. We would say that in reality, he only went for option C because he thought that the Tomlin order, that the issues could only be dealt with in separate proceedings, which was wrong, because he thought that by doing so, Eurasia would get its protection, which he had found in paragraph 46 was the primary purpose of the Tomlin order. He was, with respect, wrong about that. Because he thought that there was only to be a short timetable and that what was proposed looked as if it was going to be a lot longer, he was wrong about that. And finally, because he thought that in some way it was necessary as part of the purpose of the Tomlin order to protect the claimant's Q&M, and we, with respect, would say he was wrong about that. I'd just say just a little bit more about number 3, namely the time that it would take in order for these issues to be finally determined. I cannot emphasise enough that so far as our reading of the judgment is concerned, the judge was heavily influenced by the timetable which Mr. Justice Adam Johnson put in place for the purposes of resolving Mr. Vesnin's and at that stage NBT's challenges. For whatever reason, Mr. Justice Adam Johnson was not informed that Q and M intended to take 4 or 5 days to challenge recognition and wished to have cross-examination and expert evidence. Had he been so informed, he would have not have given the directions that he did. And obviously, the 2-day time estimate would not have been there either, in which case a completely different set of directions, much more like the directions one would see conventionally for a full trial, would have been given. And these ideas of very compressed and expedited speedy hearing would not have gained any traction at all. And it is a red herring, with great respect, to suggest that the Tomlin order itself envisaged that things would be dealt with great expedition. It is clear that under the Tomlin order, if one looks at its terms, once the court had received in, and if it received in, challenges, namely claims or interests which triggered the machinery, there was absolutely no indication in the Tomlin order that such the determination of such claims or interests should be dealt with in any especially quick or speedy manner. And that was something that the parties simply did not stipulate. My lords, my lady, I'm hard up against my 12:30 guillotine.
Well, there's a float of 5 minutes because the court was late. So
Right.
I generously identify that float should you wish to use it.
I'll be as quick, I'll certainly within the 5 minutes. I am conscious that I have not mentioned at all the two applications which have generated the two extra bundles, or the one extra bundle. I have an application to adduce fresh evidence and for this appeal to be a rehearing rather than a review.
Yes, well, as to that, I mean, the court will adopt the usual route of looking at anything we're asked to look at, and then if there remains a dispute about its admissibility, then we'll consider that and deal with that in our judgment.
I'm very much obliged.
But I don't, given the tightness of the timetable and the raft of points that arise both on this appeal and the linked appeal, we don't want to waste time unless it's absolutely crucial. We don't want to waste time on questions of admissibility.
That leaves the question of procedural unfairness.
Yeah.
Certainly, we have attempted to set our position out in full in the skeleton argument. You'll recall that the point is that Mr. Vesnin was completely unaware of the existence of the Johnson decision until the evening after completion of oral submissions before the judge.
Can I just interpose there? Because you had three grounds of appeal. The first one related to the Johnson decision, the second related to the interpretation of the Tomlin order.
Yes.
The third was procedural unfairness. Your oral submissions, have I correctly understood, have really focused on the interpretation of the Tomlin order,
yes,
rather than a binding estoppel from the Johnson decision. If that's so, the procedural unfairness points relate back to the Johnson decision, don't they? To what extent are they critical to the way you put your case?
Yes, my lady. The best way I can answer that is, could I just remind you again, going to the Johnson note, because this is what sort of came as a bit of a shock to us. If one turns up again at the Johnson note, which you'll find at
It's in the supplemental bundle.
It's in a couple of places, isn't it? It's in the call. And it's
yes,
in
it's supplemental to tab 7, page 70. And I took you on page 73 to the fact that Mr. Margolin for Q&M at that stage, paragraph 4.4 of the note, identified the two crucial documents for the purpose of assisting with the interpretation of the Tomlin order, which was Mr. Harrison's trial skeleton argument and the witness statement of Mr. Sushjov. And Mr. Harrison himself identified his own trial skeleton argument at paragraph 5.9 of the same note as crucial for resolving. Sorry, it's not 5.9. It is.
I think we had the references earlier. It's 4.4 and.
It's 5.1D.
Thank you.
And those two documents are documents that we had not seen even on the day of judgment. So we saw this note overnight. We were given virtually no opportunity to make submissions. The judge asked for a couple of sentences. I gave more, but I had to get instructions from London, from Russia at about midnight, and was able to get an email to him before 9 the following morning. His response was, "I want no more, no more submissions." Save, he said, I wanted to hear from Mr. Hankey, then counsel for Queeld and Maisper, as to why these materials were not made available to Mr. Vesnin. And so we were never in an opportunity, we never had the opportunity to make any submissions at all on Mr. Harrison's trial skeleton or on any of the other documents, which we would say plainly inform anyone wanting to know what the relevant background to the Tomlin order was, and the relevant circumstances and the purpose of the Tomlin order. So it was most unfortunate, and I do strongly disagree with any suggestion that we had ample time to make submissions, even on this Johnson note. We certainly did not, and we were not allowed to make any oral submissions because the judge, just after 9 on the following morning, said, "I want no more."
But if were we to accede to your application in relation to fresh evidence, those documents, as you say, can be relevant. Their relevance is potentially in interpreting the Tomlin order.
They are, and their relevance to my third ground of appeal is that they were not they were unreasonably not made available to us first time round.
We've looked at them, or at least we've looked at the bits you want. Are there any other bits of these documents that you say we should have in our mind when construing the Tomlin order?
We have identified that in our skeleton argument. In other words, it sets out the deep concerns and suspicions that that Eurasia had, and the
Have you? Sorry, are there any? You took us to some of the paragraphs earlier,
yes.
which I assume you did because you wanted us to have them particularly in mind when looking at the wording of the Tomlin.
Yes.
Are there any other paragraphs that we really need to have in our minds when listening to submissions about the Tomlin construction? I know you can send me away to tell me to do my homework and read your skeleton again.
Sorry.
If you like, is there anything else you want to actually show us before we hear submissions on the?
There is an overarching submission, which is that the entirety of the trial skeleton of Mr. Harrison was about the risk to Eurasia and the need to eradicate or avoid that risk. And the risk was in relation to previous dealings with the shares and the fact that there were people out there who would come forward and would make claims against Eurasia. And that's why we would say they entered into the Tomlin order in the terms they did. I'm obliged.
Thank you very much.
Lord Levy, I propose to discuss matters in this order. First, to sketch in some key points in the chronology briefly. Then to deal with what we suggest are a number of erroneous contentions on the part of the trustee that feed through into the grounds of appeal. Then to address the grounds of appeal. I don't propose to take up more time than is necessary with the background, but it does, I suggest, help to have clearly in mind certain points in the chronology. Taking those quickly in order. On Monday the 13th of November 2023, the Eurasia action was due to be tried. It never started, because the next day, the 14th, it settled on the terms of the Tomlin order that we've been to. On the 15th of November, the following day, the announcement was made. That's Supplementary 2, tab 43. On the 8th of December 2023, Simmons and Simmons wrote a parallel Russian-English letter to the trustee enclosing that announcement. That's Supplementary 2, tab 43. Then on the 28th of February 2024, although received on the 1st of March, there is the letter we saw at Supplementary tab 44, asserting the trustee's claim that the shares in Queeld form part of the estate. Now, what was not asserted was that the shares in MySpare form part of the estate, nor was it asserted that the shares in Eurasia form part of the estate. It was limited, as my lady pointed out, to an assertion that the shares in Queeld had vested in the estate. That was followed by further correspondence summarised in Zimmerman 2, at paragraph 7.8 to 7.14. That's core tab 16. I'm sorry, supplementary 1, tab 16. In the event, therefore, there was no automatic release of the undertaking, and Q&M issued the application, and it was Q&M, not Eurasia, seeking release of the undertaking. The evidence on that application consisted of Duncan 4, that's supplementary tab 15, and Zimmerman 2, that's supplementary tab 16.
Sorry, can you just pause for a second? I'm not keeping up with you.
Forgive me.
Oh, do we have a transcript today?
We don't, I think. I'm sorry, I'm told
I
we do.
graciously gave permission for a transcript.
I'm told we do then, Lord.
I hope that
We'll get one.
that we'll get one.
My Lord,
Today.
I'm told today.
Sorry, so can you just, I was up with 7.8 to 7.14,
My Lord, yes.
but can you just, in my note, give me the last references you gave?
Yes. So that is further correspondence at supplementary 1, tab 16. That's Zimmerman 2, summarising the further correspondence. Now, the consequence of the trustee coming forward in that way was that there was no automatic release of the undertaking, and there was the application issued seeking release. That was supported by Duncan 4 and Zimmerman 2, there at supplementary tabs 15 and 16. And the significance for present purposes is the way the argument was put in Duncan 4 as to what the court should do, because it's on the basis of that case that Mr. Justice Adam Johnson decided the application.
I want us to look at that.
My Lord, I'll come to this later. I'm just giving the chronology now, if I may.
Okay.
Now, it's necessary to be clear in view of what's said about ground 3, about what the trustee knew about this at the time. And if I can invite my Lord to look at this by picking up supplementary 2 at tab 46. On the 6th of March, which is supplementary 2, tab 46, Simmons and Simmons, that's the Eurasia solicitors, wrote to the trustee referring in the second paragraph to the fact that QNM had filed an application seeking an order permitting the replacement share certificates to be released, saying that Eurasia was neutral, and saying that it's for the trustee to consider whether or not you may wish to make any representations. And then in the next tab, there is a further letter saying you'll have seen from the enclosure of the email from JHA, that's the claimant's former solicitors, that the application has been listed. Please confirm as a matter of urgency whether you wish to attend. And then if I can invite attention 2 tabs further on to tab 49, this is an email from Simmons and Simmons explaining the position in respect of the bundle. That's the bundle for the hearing before Justice Adam Johnson. So they explain that JHA offered to provide copies of the March bundle to Mr. Vesnin.
Sorry, I've lost where you are.
Tab 49, my lord.
49.
49. This is an email from Simmons and Simmons explaining the position in respect of the March bundle. So they explain that JHA offered to provide copies of the March bundle to Mr. Vesnin and SBT on the 12th of March, i.e. before the hearing and before they were added. And this firm was copied to an email from JHA to Level Legal, NBT's former lawyers, dated the 14th of March, which provided a link to the hearing bundle. Now, I'll come back to that link in a moment. But the
This
position
is
therefore
tab 49.
tab 49, my lord.
That's the email of the 28th of November.
Exactly, but explaining Simmons and Simmons' understanding of what the position was. So Simmons and Simmons is the only firm of solicitors that's been involved continuously.
Yes.
So they're the only firm in a position to be able to explain what had happened, and they very helpfully set out the position.
So is this right? They offered to provide a link to the hearing bundle the day before the hearing?
They offered to provide that on the 12th, my lord, yes.
And the hearing was due to be listed?
The 13th.
That's the day before, isn't it?
Yes, it is, yes. As my lord identified, that happened. The hearing then took place on the 13th. And I'll come and look at in more detail in a moment about what was being argued. But in overview, QNM was saying that what had been articulated by NBT and the trustee did not engage the protections in the Tomlin order at all, and therefore the undertaking would be released.
Going back while we're on chronology, this application sought release of the share certificates. It was issued when?
The 5th of March.
And did it seek any form of expedition? Why was it issued? I mean, it was issued to be heard in the applications.
It was.
Presumably on the basis that it was too urgent to be heard in the normal way.
There was some debate about that before Mr. Justice Adam Johnson.
Okay,
He wasn't very happy that it had been listed in
No,
that.
I can understand that.
I wasn't involved at that time, and I'm afraid I can't shed any light on the listing.
What was said to be the urgency?
Well, there was some debate about that from Mr. Adam Johnson.
Yeah, no, but I'm just asking what was said to be the urgency.
The question needed to be resolved. I didn't went much further than that.
Because it was the application was made the first day it could be made.
It could have been made, yes.
And did Q&M explain why it was that they needed the shares so quickly?
I'd need to check back through the evidence and look at the way that was put in Dunkard form. But there was complaint on the part of Justice Adam Johnson that's to be listed in that way. It's fair to say that. Now, to return then to the hearing, Q&M was saying that what had been articulated.
Just to be clear, I'm not interested in the inconvenience to the court of having to deal with something urgently in the applications list, which was part, I think, it's Justice Adam Johnson. It's just that what were Q&M trying to achieve so urgently?
The release of the shares to them.
I know that. Why?
That I don't think was explained in evidence, but I will check if I may have the short adjournment and revert on that. Now to revert then to the arguments, Q&M was saying that what had been articulated by NBT and the trustee did not engage the protections in the Tomlin order. It was an in limine objection, if I can call it that. NBT, which is the only other party before the court apart from Eurasia, was simply asking for an adjournment, its English legal team having been instructed only very shortly before. Now, it's correct to say that the order envisages a 2-day hearing, and what's said against me is, well, you couldn't possibly use a 2-day hearing to actually decide the question of recognition. But it wasn't being suggested that the trustee would need to actually obtain recognition. One sees that from the has not tried language in the note of paragraph 4.5 on the part of counsel for the claimants. The point was in circumstances where the trustee had not brought forward a claim in this jurisdiction to recognition, there was no reason at all for his asserted claim to be taken into account, that he would need to at least be bringing forward a claim to recognition if he was going to participate. That's the distinction between, on the one hand, actually obtaining recognition, and on the other hand, coming to the jurisdiction, submitting and positively advancing a claim. So the fact that Mr. Justice Adam Johnson envisaged a 2-day hearing doesn't envisage that he thought that the undertaking must necessarily remain in place until these claims were decided, not least because nobody could know what they would look like once they came finally to be brought forward, or for that matter, whether the trustee would actually come forward. Now, continuing, if I may, with the bundles, because it's quite important to understand this, and if I can invite attention to Mr. Beckwith's statement on the appeal, that's supplementary 1 at tab 10. This is Mr. Beckwith explaining supplementary 1, tab 1. So this is Mr. Beckwith's first witness statement, and he explains at paragraph 14 on page 10 that on or around the 15th of March, NBT's lawyers, NBT is the other party that was coming forward, sent a link to the March bundle to Elwy. Elwy is a firm of Russian lawyers. And then a little further down, Elwy sent the link to the trustee on the 18th of March. And then it said the trustee did not review the March bundle. Now that, we suggest, is a careful piece of drafting that notably doesn't say the trustee did not in fact have the bundle, that is, that he did not use the link to access it. And if I can also invite attention to what the trustee was saying at that point.
Yes, it just says he was on board.
He was sent the link. But I'm going to invite my lady's attention at the moment to what the trustee was saying at that point about what he wanted. And if I can invite attention in this context to back in supplementary 2 to tab 45. So the trustee's communication to Simmons and Simmons at the 5th of March, an email. And it says at the top of 653, at present I don't have any material, and then I would be grateful if you can provide me with all relevant information and documentation in order to enable me to take a position on the issues raised. Now, we suggest it would be surprising, having said that, if he didn't access and read the bundle. Now, it's in the context of ground 3 that I make this point, because ground 3 rests on the assertion that the materials before Mr. Justice Adam Johnson were not made available by the parties to the Tomlin order to the appellants.
Sorry, what? So what's your submission that we should do with what you've just put in front of us? Are you saying what? You say it's a surprise. What? Sorry.
This is going to
finding you want us to make?
It's going to allow the Marshall point, Lord, that these materials were available with reasonable diligence to the trustee in advance of the hearing. That the trustee was provided with a link to the bundle, and his contention is, I didn't have those documents to deploy before Mr. Morgan, when the matter was before him, but in circumstances where back in March he had been provided with a link and was saying he wanted to be provided with all documentation, then he could, with reasonable diligence, have obtained and reviewed and considered the material he now says is important.
So, but that's your answer to a procedural unfairness argument.
It is.
I'm not sure where Ladden Marshall comes into it. Why do you mention Ladden Marshall?
It's the further, because that goes to the application to adduce fresh evidence. And I'm just trying to deal with that in its correct point in the chronology.
Sorry. Fresh evidence of what?
Well, at one level, none of this is evidence at all. It simply records what people said.
It's all part of the tortuous procedural background of this case.
It is, my lord, yes. I won't press that point. And I'll move on, if I may, to the errors that we say the trustee's case is founded on. Now, the first of these is what was in issue before the erasure action. The trustee contends that what was at the heart of the erasure action was the identity of the UBO of Q&M. He says that was the principal issue in his skeleton, paragraph 5, apparently meaning that the court at the trial of the erasure action would have investigated and adjudicated upon that question. Now, we suggest that's not correct. As one sees from the pleadings, the principal, indeed the only issue, was whether Eurasia's refusal to issue replacement certificates was a permissible exercise of the discretion conferred by the articles. And to answer my lord's point, Article 9.6 is pleaded out in the pleading at core tab 7, page 91, and that includes an entitlement to indemnification to the satisfaction of the board. So the battleground was whether the board's refusal to issue replacement share certificates without indemnification in the terms they sought was a permissible exercise of a contractual discretion. That's what was in issue. That's also seen.
That was what was this issue you say in, or the principal issue in the erasure action, out of which came the Tomlin.
Lord, precisely so. Yeah.
So you're just dealing with this is your second head, the erroneous contentions.
The erroneous contentions.
And this is this the first one?
That's erroneous contention 1.
Right. Okay. I did put one in my note. I like to follow these things by subheadings, otherwise I get very lost.
Lord,
so that was 1.
That's error 1, and one can see the same thing in Eurasia's trial skeleton. That's the additional bundle at tab 4. There was a list of issues. None of those is about the identity of the UBO, at least not correct. Now, what I'm not going to invite my lords to look at that skeleton in detail, but in summary, what Eurasia sought to do was justify its decision by pointing to what it said were risks in providing replacement certificates. One of those, one only, concerned the control of Queeld, not also MySpam. But that concern wasn't something the court could or would try. The court was going to try whether the existence of those concerns justified the exercise of a contractual discretion in a particular way. That is to say, whether the exercise of the discretion was Wensbury unreasonable, that being the current state of play of the law on contractual discretions. Error 2.
Why do you say Wensbury unreasonable? It's got nothing to do with Wensbury.
Or without a detour
It's a question of directors' fiduciary duties in exercising their powers under the articles, isn't it?
without a long detour into that, which isn't directly relevant, which isn't relevant. It's a question of a contractual discretion, and the current state of the authorities on contractual discretion.
Contractual. What's the contract?
The statutory contract consisting of the memorandum and articles.
Yeah, which is ordinarily the power is given to the board, isn't it?
It is.
And that has to be exercised in accordance with their fiduciary obligations.
Yes.
So I'm struggling to understand why Wednesbury Unreasonable suddenly starts rampaging around company law.
Well, it isn't directly relevant. I'll cut that submission back to was it a permissible exercise of discretion, if I may, and move on to the next point.
Okay, because the company lawyer in me is just squealing.
My lord, I'll move away from that point
Right, okay.
and say that the issue was simply whether it was a permissible exercise of discretion. Which,
I don't think the squealing is necessarily limited to a company law.
without a long foray into the law about contractual discretions.
Yeah, okay.
Now, error 2 is about the relief for which Q&M sued. The assertion is that Q&M sued for delivery up of the certificate. That's the way it's put in the skeleton of paragraph 10. Now, that might be sought to suggest that the certificates had been issued and we were seeking to recover possession of them as a chattel. Now, that's not correct. What was sought was to compel the issuance. The certificates did not come into being until the Tomlin order was agreed. The certificates were actually issued by the registrar, Link, and handed over almost immediately to the claimant's solicitors. So the certificates as a piece of paper were never in the hands of the company at all, and were in the hands of the company's agent, its registrar, for only the very short moment in time between their being produced and their being handed over to JAJ.
And after the Tomlin order.
And after the Tomlin order, yes.
At the point of the dispute, they don't exist.
At the point in time of the dispute, they don't exist. There's a further point it's necessary to be clear about. It's obvious, though, that the certificates, of course, are not documents of title. They are merely evidence of title. That as a piece of paper, they have value only as evidence of title. And the question who is in fact the legal owner is determined by the register.
But they can facilitate transactions. So to that extent, they have value as evidence.
Indeed, and given that articles often say that the directors need not register a transfer without delivery up of the certificate, they can have very considerable significance. That brings me to the third error, which perhaps I can start on before the short adjournment, which is the contention that the trustee was at the front of the parties' minds. That the assertion is that at the time the Tomlin order was concluded, the trustee was, quotes, the principal third party likely to object. That's skeleton paragraph 4c, Roman 3. Now, we suggest that that's incorrect in 3 ways. First of all, it's incorrect as an inference from the materials relevant to the question of construction. Secondly, it's incorrect as a statement of fact. And there's a linked incorrect point, which is the assertion that in order to object, the trustee needed to actually obtain recognition. Now, picking up on the first of those points, the idea that the trustee was the principal party likely to object. As I'll develop later, the materials properly relevant to the construction of the Tomlin order do not extend beyond the Tomlin order and the pleadings as they stood when the action was compromised. And while it's correct that the trustee was identified by name in the re-amended defence, that's paragraph 94, capital A1, at C, core 9, 122.
Core 9, page 1.
Core 9, perhaps you can turn it up, Lord. It's
Yeah.
core tab 9. The document starts at 122.
Yep.
And then on 160, there is 94 capital A point 1, where the notices from the trustee to link, that's the registrar, and the company are pleaded out. But the potential for a claim by him was neither the only nor the principal point relied on. Indeed, he was added by re-amendment. The opposition to the issuing of fresh certificates had been there right from the beginning. And my friend pointed out the claim by Morendo earlier. That's pleaded out in 94 capital A point 2. And indeed, if it's relevant to have regard to the trial skeleton, one can see.
Shall we look at that?
My lord, I was going, if it's convenient to go to that, yes. That is,
Shall we look at that? I was going to say, shall we look at that at the short adjournment,
my lord, yes.
if that's all right, after the short adjournment? All right, thank you very much. We'll come back at 2.